I think future.
I can see that. Based off where everyone else is sitting, I'm like a little bit off, but I think I have this for your capacity. But
Are we gonna introduce a new?
yeah,
Yeah, we were gonna go to a new co-president, actually. I'm also resigning.
yeah.
I've had enough.
This is manager, but I don't need it right now, so.
They keep it down, but they can get 2 inches of.
Oh,
free
is
room.
it, so then you don't have.
Yeah. Yeah, so every week I defy them.
No, please let me. You don't need stamps in the office. I have no idea. Man, me either. I was there literally all day for the past 2 days and I just didn't.
Sorry, Tom.
Yeah,
Sorry about that.
it's actually perfect for that. I know it's gonna be stuck out there as I'm gonna write the stairs.
I try to email or text you guys like right beforehand, it's like, but I didn't do it.
That's usually would be the first time I pay attention to it.
Sorry.
Impeach Austin. Impeach Austin? No, what?
I resign.
He didn't even start.
No, I have these cards that I had for like 3 weeks.
Oh, yeah, I can take it. Tallahassee again, yay.
Actually, if I have it.
No, it's fine.
I'm literally
Just
so
wants to
obsessed
give you
with
the
plastic.
I mean, I parked in the rights and I have an FDA folder in my car, so I usually put them in my driver's seat. And then whenever I make it to Tally, I just go to the office for however long they ask me.
Is there what we should be looking for specifically on the Zoom package?
Shane.
I'm sorry, what?
Is there anything specific we should be looking for, the Zoom package list?
Shane? And I don't think Dr. Travis is joining us today.
Okay, sounds good then. Do you have the recording going? Are you guys?
I need to get into the notes doc, I'm so sorry.
You're good.
Let me email you over what we've got today.
Okay.
This is.
My computer's like not acclimated to the internet. I don't know like what.
Mine decided to take 2 minutes.
It's like, you close me and open me in a new location.
I get it.
It's like, well, yeah, that's kind of how this goes. It's tweaking,
It's just not working, yeah.
like nothing is.
Oh, what about Michael? Michael, he's on. Oh, he's on, okay.
He's on, yeah.
Sorry.
Thanks to everyone who's here.
Yeah, thank you guys.
Also Carlos. Thank you, Carla.
Also, I thought that we have a Facebook, but apparently I've been posting on Brandon's Facebook for the past.
Oh, wow.
I was like, wow, Brandon's like posting all of these things. That was me. And I broke into her house to do it, actually.
Thank you, Brett.
Hopefully we're not.
Yeah,
We're roommates.
I know, I'm just
Okay.
okay. I know that.
Ron,
The recording doesn't know.
But now we do. I mean, we're not gonna put that.
I'm just like, oh, sorry. So I really just want to know these on there. I was like, I'm just gonna just show this forward by the end of this.
Thank you. I am so sorry, my computer is just full.
You wanna-
I need to,
You should get it.
yeah, I can start there.
I'm
Can you
gonna
pull
know
up the doc?
if that's for you. Like, I can see tongues.
Okay, will you do that until I can figure out what's going on?
Yeah.
It like will connect to internet. I fear that it's trying to do like updates or something.
How bitter.
I know.
Mine stopped doing updates, so it has a red light. It's just like your device is missing important updates. Every time I tell it to update, it doesn't. So I'm just kind of like waiting it until it shuts down at some point.
My computer was literally functioning 20 minutes ago in Turlington, so I don't understand what has happened here. I think Ava's got it for 1 second and hopefully.
Hold on, I'm waiting here.
Thank you. I don't want. Can I?
Oh, and the article should be it. Yeah.
No, send those, let me see.
Probably there's like an old spring in there.
I can't do it. It's gonna drive me absolutely.
Yeah, that is pretty
Gonna
bad.
drive me-
I'll try not to.
I just got your email, so.
Okay, good. So we also, I think we're close to also bringing 24. I brought a copy of it, but we were hoping to just do discussion on 24 because I think we may be saying the same things, but I think we may have been saying it the exact opposite of the way we meant it. So we just like to talk about maybe rewording it.
Alright, which one did you want to start with today?
We can start with, we start with 28.
Right? Sounds good.
For copies, I only made 6 because that's how many people have been typically coming, so sorry about that.
Are you good? For the record as well, this is my wife Lexi, so she's not a member of the bargaining.
How are you? That's okay.
Won't be a surprise.
Open to the public. Anybody's allowed to come.
You on the screen, so.
Yeah.
The car shop.
Yeah. Alright, and everyone on Zoom can see that, okay?
Okay, great.
Should be good.
So I don't know if it would be helpful, Austin, to bring up, maybe the previous 2 versions. We were having a hard time finding where the changes were. So,
Okay, for 28.
yeah, so I don't know. I think this is the same version, other than I tried to clean up some of the crossouts. I don't think we actually changed any language, assuming that the removed, like, proposed deletions are correct. But I thought because this is one of the more technical ones, we should probably go through it very carefully.
Yeah,
Because we've made a lot of changes and some of these individual words are very important. So I don't know if could we kind of just go through it
yeah,
to make sure that it's what we both intended it to be?
yeah,
Because I think we were close on it before, but you can see all the different colors of all the times we've touched it.
yeah, it's kind of a little bit of a mess. Here, I think I've shared the screen here, so everyone on Zoom, let me know if this works, but we'll try to try to do this, you know?
Yeah.
And then it's even more confusing. So this is the version we gave you last time, this is the version we have today.
Yeah, and what I tried to do is, like, the stuff that was stricken, I tried to take it out to try to read the sentences more clearly, but let's go through it and make sure that, again, with everything stricken, it matches, and then also with the stricken stuff taken out, do the individual provisions stand on their own as we mutually intended them to?
Okay,
So, I mean, I think everything in A, like, I don't think any of that is really changed, other than I missed an extra space before has on line 6.
okay, yeah,
So like, I don't think that's a big deal. So if we go to B, under circumstances not covered by section 28.1A, which is above, the university adopts a new regulation, policy, or resolution, or amends an existing regulation, policy, or resolution that has a direct and substantial impact on wages, hours, another term or condition of employment, or any other provision of this contract.
yeah,
The university shall satisfy any collective bargaining obligations with respect to the change prior to implementing it for members of the bargaining unit.
okay, yeah, I think that matches.
Okay. And then in these cases, UFFJU may decline to reopen the relevant articles of the collective bargaining agreement until the end of the contract period in accordance with Article 23, preventing implementation of such changes with respect to employees in the bargaining unit.
Yeah, I think that's the same, yeah,
Okay.
yeah.
All right, then I think we're good. And if you guys are amenable, I can load it into DocuSign on Monday.
Yeah, that sounds perfect.
Okay. Any other questions? Good, all right. I'm with that one.
Great,
Let's talk about 23.
okay.
Kind of suggest maybe the same thing on this one. Again, these tail end ones are the more sort of legalese, jargon, boilerplate things.
Yeah. Can everyone on Zoom see that? Okay, I know I just switched it up, but I think I'm showing the screen, so it should be okay. If you can't, let me know, but.
We'll share that. Do you mind?
Did everybody get a
Yeah,
copy? I have one more copy if somebody else.
Oh,
wants a
that would be
copy.
great, if you don't mind. Then the two of you. And me in my small
There you go.
computer for it. I don't need to be bad at sharing.
Thank you.
Yeah. This is
Yeah, so I don't know, do you want to put up the other one on
Yeah,
this one
yeah, I can do that as well.
too? Like I said, I think, just to make sure if something comes up as being different, let's kind of talk about it, because I don't think.
Okay.
All right, so I think the first one, there weren't really much changes other than the university and that wasn't a new change, that was a change that was already there.
Yeah,
So let's go down to 23.2, where again, I tried to remove what I think we agreed to all strike, but let's kind of go through it. No obligation to bargain. The university and UFFGAU during the term of this agreement voluntarily and unqualifiedly waive the right and agree that the other shall not be obligated to bargain collectively with respect to any subject matter, whether or not referred to or covered by this agreement, even though such subject or matter may have not been within the knowledge or contemplation of the parties at the time of negotiating or signing of this agreement, except as otherwise provided in Articles 24, 25, and 28.
okay, question about this year. I think in healthcare, we had hard coded a reopener following negotiations. I think that's outside the purview of Articles 24, 25, and 28.
It would be listed in whatever
That listed in the other,
I think, right, I don't remember which article it is, and of course I can't pull it up.
yeah,
For
There's
which,
one where
which
it says,
provision, ma'am?
like, the length of the contract, and then there's a second one that says, like, we'll open Article 10 each
So
year,
that's term of contracts.
that
Amendment and
24?
duration, that's in 25.
25.
yeah, and have we hard coded the healthcare reopener in that? Because we talked about that and got that for the MOU for healthcare.
Oh, so do you want to put, I mean, you could put the reopener in 20, if you want to put them all in one place. I mean, we can put it in 25 if you'd like to.
I think we should in regards to this one, just to ensure that, that reopener is still following this regulation.
All right.
So that might just
I'll
be
make
a
note
change to
on
25, but
that. So rather than putting it in 23, you'd rather it go in 25?
just, the healthcare reopener that we negotiated in the healthcare article.
Yeah,
Just add that to 25.
Add that to 25, just so, because this is saying that
Oh,
there's
not in
obligation to
23,
bargain,
in
except for
25,
23,
okay.
24, and 28.
okay,
Or
add
24, 25, 28.
healthcare reopener to 25. Is that 25, I think we gave you last week.
Yeah,
Okay.
well,
So we
we
can talk
discussed
about
it. I think we gave you one and you
Yeah.
said you were gonna go back and discuss it.
Oh, yeah, yeah. Okay, well, we can talk about that too then.
Yeah.
All right. Okay, let me make a note on that one. So does that affect what we have to change in 23 though?
No, I don't think that affects
No.
23. I
Okay.
think this one is just saying that we would only reopen based off 24, 25, 28.
Okay,
So I would wanna make sure that that is
Either.
under one of those articles.
Gotcha.
For that reopener.
yeah.
But I think the text is correct.
Okay,
I
and
think
then
Matches what we had at least.
I think we're good on 23.3 there. I don't think there were any changes there.
Okay,
All right, let me make it, I got a note on adding the healthcare reopener to 25. So other than that, I mean, obviously getting everything in one color. The other thing I was gonna ask you about is I think we had braces or brackets around 28 because 28 we hadn't necessarily
Right.
agreed to yet and it didn't appear because it's a new article.
yeah,
I think that it's possible that when we get done, 28 is gonna be the wrong number. It's more likely to be, I mean, my recommendation would be we actually insert it before definitions, because definitions is typically like what you put normally is like, we could make definitions into Article 27
okay.
and then make that 26. I don't know how y'all feel about that. I mean, God bless you. I mean, normally you put. I mean, we could put it anywhere we
Yeah,
want.
I think that makes sense. That's fine. Having
Okay.
definitions at the end, just so it makes sense.
All right.
I think it's fine.
Move definitions to 27. Because I don't think we've signed that one either.
Yeah,
Relations to 26. Add healthcare reopener to 25.
What's the definitions now? It doesn't have a number yet.
It's 26.
That's 26.
Yeah, so what we would do is we would just push definitions out to 26 or out to 27 and put the new 28, which is a new article, in as the new 26.
Okay.
So it would just shove definitions to the end.
Mhm.
All right,
Okay,
all right. All right, how about we go to 4?
okay.
Actually, no, let's do 24. It's 24. This is, I didn't email it to you. This is more of a discussion.
Okay,
But
well,
I don't know if this is a case where we talked about one sentence so long, maybe we almost talked ourselves out of it, but here's kind of the thing. I highlighted the part that we're really kind of, oh, you know what? Awesome. Let me email it. I don't think I emailed. Let me email it to you real quick. That way you can put it on the screen.
Do we have another one?
you can,
It's fine, I don't need to.
Oh, if you get on the Zoom, you can
Okay.
probably like zoom in.
yeah, let's do
Like,
that copy, put on Zoom, we just got a copy yet, but,
Here we go. It's going right now.
okay.
I'll give you a minute.
I'm stressed.
Just give it just a minute here at Zoom, and then we're back to it. Okay, just got the email.
Okay. So 24.
40, this is for you. Apologies. My computer's also suffering with this. Oh, it's because 24 is on the other screen.
Okay.
I mean,
So here's what we kind of wanted to talk about. We weren't sure, we thought we understood, and then we weren't sure we understood. So we want to go back over and make sure we understand.
okay,
So when it comes to the second sentence, the third sentence in 24.2, which starts in line 20. We want to make sure that we're discussing the same cases that are contemplated in line starting 18. So here's what we're trying to, let me just kind of read it and I'll go through it. So this is the section about when a law is passed. So, right, if any provision, starting in line 18, if any provision of this agreement is rendered invalid by subsequent enacted legislation that is later enjoined, repealed, struck down, or amended in such a way that permits the provision's enforcement, the language in the provision takes immediate effect. Okay, so this is contemplating a situation in which there's a piece of contract language. There's a law that comes out that says that we can't do the provision anymore.
Correct.
But then the law gets, for all intents and purposes, temporarily invalidated that would allow the provision to continue to occur. That's the cases we're talking about.
Or permanently reinstated, right?
Right, but that's the next sentence. So
Okay.
so this is the relationship between those two events is what we're trying to make you understand. So in that first sentence, we're talking about. Oh, no, you're right, Hannah, because it talks about struck down.
Mhm.
So it could be permanent, but, so the language is in the contract. There is a law subsequent to us agreeing to it that makes it so that we can't do the provision anymore, but then the legal status changes either temporarily or permanently, and now the provision can take effect, and we have to immediately put it back in place.
For the sake of everyone imagining what this is, can we
Right.
just use dues deduction as an example?
Sure, yeah,
Right, it has not gone back into effect, but dues deduction has become illegal.
Right.
Through a law that gets passed.
right,
There is a court case, and so in the case that would then be enjoined or struck down, this is now what's gonna happen,
right.
the subsequent language.
We would go back to doing it, because right now, we're not doing it. But there's still language in the contract that we do it, except that we can't because it's illegal.
Correct.
I know it's kind of like,
So the court case did end up ruling that that was not cool. If, for everybody's like, just to make this a little bit worse,
Mhm.
kind of, unfortunately, it makes it more confusing, yeah, sorry, it's gonna make it more confusing. But that court case, they decided that was not okay, we're still not doing due deduction, that's fine, but that was the end like verdict. in that
So
case.
I would somewhat disagree with the interpretation that was not okay, because it was kind of a, in my opinion, it was kind of a split decision.
Yeah,
What they said was, it wasn't okay to do it in that case, and the facts of the case are specific to the individual people that brought it, because there was different groups.
yeah, that's the
But
problem.
if like, if you're talking about it in at least one of the cases that I read, they said it wasn't okay to force the change without bargaining it during the course of the current contract.
Mhm.
But because the case took so long to resolve, they were then in the status quo period, during which they would be legally prevented from signing a new provision or a new contract because the legislation had rendered it illegal. So they couldn't enter into a new contract. They may have made a mistake by changing it during the course of the previous contract,
Mhm.
but it was moot because now they were in the status quo period and they couldn't sign a new provision anyway. Like,
But
now
it's
that's
just
my
like-
own
yeah.
version of interpretation of the
Yeah,
case that I think. it
that's,
referenced.
yeah, that's exactly what we're talking about,
Okay.
yeah, cause like that was the, the
Yeah.
ruling was exactly, yeah.
If I am interpreting that correctly,
Mhm.
that is why we put reinstating in. Right? If we go to impact bargain over something that immediately becomes illegal, right? So for dues deduction, if we immediately go into impact bargaining
Right,
and we are forced to take it out,
right,
which as you remember, that was the conversation, we were told that we had to take it out.
right,
Even though it says in our contract that language can not be enforced if it's illegal.
right.
Right? That in that case where we were forced to take it out because of impact bargaining and then something comes down, we would wanna put that language back in. It's not just, preserving it,
Right.
right? So that it goes back into effect, because now it's been removed.
I get what you're saying.
Okay.
And so this is kind of where I'm going with the addition of of line 18 through 20. What we would prefer to do is, rather than going back to a previously ratified agreement and like reaching back and pulling something, is to create a situation in which the language would be permitted to endure with a qualifier that it was currently not enforceable. So that the language is actually not taken out of the agreement, in accordance with what we have listed for 18 through 20.
So you wanna do exactly what we asked to do for dues deduction, that you guys said no to.
Well, but we didn't have this part in the contract. See, so this sentence didn't exist in the contract then.
I understand.
Right.
But that's exactly what we had asked for.
Right, but we didn't have the sentence that permitted us to do
Okay,
it.
so we're on the same page.
Yeah, I think we
Yeah.
agree. I think we kind of agree in the concept.
Yeah.
But we would, I guess in a sort of a higher level sense, we would want the impact bargaining, whatever the results of impact bargaining are, to stand on their own. And not compel you to impact bargain something that you didn't necessarily agree with, because that situation needs to be treated in the time and place that it occurs.
So we're all on the same page, we should not have had to impact bargain it, because they should never have put in a law that goes over the
No,
contract.
I'm not agreeing to that statement.
Okay.
Yeah,
That makes-
because there was,
Yeah, I just wanna make sure that-
the legal evaluation of the strength of the contracts clause against the state piece of legislation, like that's above my pay grade. I mean, obviously the courts are gonna decide that, like as a categorical agree, disagree, you're not gonna get an official position from
That's
us on
okay.
that. But in terms of when we have to engage in impact bargaining in connection with 24.2, our preference would be that whatever we agree to, if there were provisions that were preferable to what we impact bargain, it should be in some way, shape, or form reflected in or contained within that agreement, rather than saying effectively, well, we have a contract for 2025 through 2028. But if this happens, then we're gonna go back to the previous contract of 2023 to 2025, and we're gonna implement that. Because really, that should be contained within that contract in some form or fashion, whether it's as an appendix or hardwired into the contract. Because when someone goes to evaluate or read it,
Mhm.
they should be able to look at everything that would be like contained within it, you know what I mean? Or we could bargain it again, but
Okay.
I get what you're saying is, look, we don't wanna have to bargain it again. We have a piece of language that we like, it gets made illegal by a subsequent legislative act. If the thing that made it illegal, we would like to preserve our language, then that language should be in some way, shape, or form contained within the contract, I guess.
So I think we're on the same page here. I think
Yeah.
we're good. So in future scenarios, you know, if we had to do, if that same situation came down again, right? And we
Right.
had to go to impact bargaining because something was made illegal. This would allow us to say, hey, we can just add something to say this is invalid because of this, and it becomes valid in XYZ cases.
Yeah, I think if you're,
Without changing the rest of the language, we can say this following article is rendered invalid until X, Y, or Z appears.
I think it's believable that if you remember, like, back on that MOU, there was that first paragraph that contemplated the fact that, you know, this has been, that we did in the MOU, that contemplated and referred to the law, and it contemplated and referred to why we were doing it, and so on and so forth. I think that there are ways in which we can, to your point, I think we can construct it in such a way, in an impact bargaining sense, that says, okay, look, we realize that we have to do this right now, but we're gonna do it temporarily. You know what I'm saying? It's not enforceable, but we don't necessarily want all of the language to go away.
Yeah, we can preserve as much as possible,
Right.
just we're
The,
preserving.
the key thing is, it becomes, quite frankly, I think it becomes a little more difficult in that situation, for you all. Just frankly, because you all have to be careful about. I understand and appreciate, you all don't want to necessarily vacate your legal position on whether or not something has to be impact bargained. Like, if the union takes the position, and again, I'm not telling you how to bargain, like, if the union takes the position that you're willing to take an impact deal and acknowledge by MOU that something is unenforceable, I realize that your position might have to be nuanced, because you may also simultaneously be fighting a lawsuit saying that, you know what I mean? So like, I appreciate that it's complicated.
Yeah, and I think it would be a case by case basis as we get to it. I
Right.
think, if I'm understanding, I think we're on the same page. I think this language makes sense as it's written down, and I
Okay.
think it's something that we'll go through, I'm sure, and make sure we're not missing anything, but as it sounds, and as you're making it sounds like we're good on
Okay.
this, yeah.
All right, so then the next sentence is, if any provision of this agreement, so this is the part that I changed, is because I want to make sure that the second sentence is only talking about cases that were contemplated in that previous sentence. In other
Okay.
words, I know I'm not trying to make this more complicated than it needs to be.
Yeah,
We're only talking about provisions that had been rendered invalid. We're not talking about a different set of provisions,
right.
if that makes sense.
Mhm.
So we're containing the impact of lines 20 through 25 to those provisions which had been affected by lines 18 through 20. Does that make sense?
Yes,
Yeah, it's all one provision. It's a sequence of events.
Right, but the way that it had been written, it had the same, if any provision of this agreement, like, it wouldn't necessarily. We just want to make sure that it's a subsequent effect. Like, that was, I think that was the intention.
Yeah.
We just didn't think it was terribly clear.
I think
So-
this works, yeah.
Okay, so what we'll do is, we'll go back and, appreciate that discussion, knowing that we will go back and make sure that this is exactly how we want it. And give it to you as a formal proposal, because it's probably only 60 or 70 words, but good night, this is.
Yeah, I mean,
It's-
it's obviously
it's
when it's
super
complicated, we have
complicated,
to, you know. I think it's
Alright.
good. I think the
Okay.
changes to this is gonna affect it so we don't run into the same situation we get.
Okay, all right, thank you very much for that. All right, now if you want to switch over, we can do 4.
Before we fully move on, just anybody, we'll cover that very extensively in debrief.
Yeah, it's-
Anybody else, it's broad,
It's a
but I don't wanna
complicated
waste
one.
it of the entire committee's.
All right. It's not stapled, so I'm gonna give it to you in packets, but kind of keep them together.
Thank you.
You might want to share.
Yeah, we can-
All right, thanks.
I can look at this, really, it to be at the end. Probably.
Can I ask a lingering question?
Go ahead.
What are we gonna do about dues deduction? Is that fully closed?
It's,
Because in this case, like, this is language that we're implementing now for the future, but we have removed language in this exact case. So
Right.
are we just,
that's a statewide can of worms.
we're just,
with the language we have now, no one would be, yeah, I think we would not be obligated, and then we'd be obligated to go back to doing it again with due section if it was made legal. Right, this would make it in the cases where it's made illegal, in that moment when we're doing impact bargaining, if we go to impact bargaining, we would say, hey, we want to preserve this language, and if this becomes legal again, this becomes legal.
I
Since we've already done it, we just go with the contract as it is.
Yeah.
So if we would want to add that later, we'd have to reopen.
You'd have to rebargain it.
We'd
I
have to
think.
rebargain that. Yeah, but that's a whole thing. Yeah, it's fine to fix that, so in the future, we don't have to worry about those things later on.
At least for one contract cycle, right? Which sometimes that's how long cases take to where it's like an entire contract cycle.
Yes.
All right. So I think we're really, really close on this.
Yeah,
This is another one where we've had so many back and forths. Even after we're done today, I invite you to please do a careful line by line, side by side, in case I miss something. I'm not gonna try to miss anything we changed. But, you all had, suggested a move from, further down to 8. I think we're okay with that. You want an explicit statement. I'm not gonna lie, we're probably using the way that it's written here, we're probably going to use a very specific contract reference. That way people understand where it comes from in accordance with contract, CBA, blah, 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 blah. Please note, so on and so forth.
yeah, I mean, the point is just to make it very clear, so I think that's.
Hannah, this is one that you provided some good information on down in 42B6. I don't know why the line numbers came off this one, so I'm sorry about that. I don't know why they disappeared.
That's okay.
But down in 42B6, which I think was kind of the next one we spent a lot of time on. At least where we had been. I think we understand what you kind of want now. I think we're good with that.
Okay.
It may not be the worst thing in the world when we get ready to do some of these. So maybe in an Article 6 consultation session, assuming we get this whole thing done and wrapped up, and say, hey, look, can we look at some of these together? And make sure that you all think that this conforms to what you had intended, and or are there any questions? Because, I think the intention is that we want to, once we get to agreement on this, we want to make sure that we're immediately abiding by it. We don't want to inadvertently, like if we interpret it one way, you interpret it another way. Let's just give some examples
That's
Yeah.
really fine.
without putting them in here necessarily. Be like, okay, look, here's the one for Susie Smith. Here's one for John Jones. Do these
Yeah.
make sense? Do these match what you're expecting? So there was this criteria concerning reappointment had previously been in a thing down below. You wanted to move it up to number 12. I think that's fine. My comment stands, and I think we talked about this last time, in that we just want to make sure that the criteria are going to be stated as a minimum expectation, not as a guaranteed expectation. I think there's an important difference there. It's not like we, meaning the management, should not construct the letters that say, if you do the following things, you are guaranteed to be reappointed. That was a discussion we've had for quite a long time. It'll say, I don't know if it'll say at a minimum, but it will say, you must do at least the following, or these are the criteria for, when considering reappointment, we will consider the following, or something along those lines. So it doesn't imply or act as if you check all the boxes, you're guaranteed to be reappointed, which I know was one of the things that you all have brought up before.
Yeah,
So we want to be sensitive to that. So then we move over to 4.5. I think last time we had good conversation about the fact that we're not going to be creating public records and all that kind of stuff. If we can give you guys the letters of appointment, basically the details about it without having to do email searches and all that kind of stuff. I mean, we'll give you the written information regarding it. I just want to make sure we have a clear understanding of exactly what the parameters are there. I think that was good conversation last time.
okay,
Down in number 4.7, again, by changing just it from A to additionally, we think that captures what we wanted it to. And then it talks about, I know a long time ago, adding the voluntary resignation was fine. Okay, so I think everything is there. There is one, it is a substantive change, even though it's only one word. So let's go down and talk about 4.8B1. Which I think is really the only, I think we're actually to a point now where we're down to a single word on Article 4.
yeah, I think so.
Which this one's been through the ringer. So here is we wanted to one more time talk about this, because we talked about a couple different examples, right? And Hannah, you gave some really specific examples last time. We just kind of wanted to talk about it one more time and take a shot at it this way. All right, continuing 9-month employees who receive summer appointment that is outside of their unit and we inserted or, and I'm gonna explain why. Or is substantively different from the regular 9-month appointment, may or may not be awarded a tuition waiver for the summer appointment at the discretion of the hiring unit. The unit's discretion to award or not award a tuition waiver must be provided to the GA at the time the appointment is offered. So this is, the reason we reinserted it was we thought of a couple cases, and we just want to make sure that these are cases that your position is, no, we do not want that person to be hired as a GA, which will almost assuredly result in the person who is hired for the job being either an adjunct or OPS. But if that's really what you all want, then I guess we could do that. So let me give you an example. If a different unit, if it's a TA, and I know we kind of talked about these exact examples, we just want to go over it one more time. If you're a 9-month TA and you're if you're in one department and another department has an opportunity for you to teach over the summer that your department does not, but you'd still be teaching, the GAU position is that person should not be able to be a TA over the summer. They must be hired as an adjunct. I just want to make sure that we get it.
That is not what we were saying. We're saying they should absolutely be able to have that opportunity, but that unit needs to
Pay the tuition
pay the
waiver.
tuition.
Okay, yeah, all right, fair enough. Similarly, if you are a research assistant and there's an opportunity for you to go to another department and do research over the summer, you would only want that department to be able to hire that person if it came with a tuition waiver.
Yes.
Quick
Okay.
question for clarification. When it becomes having a required tuition waiver, by definition, is that a graduate assistant? Like you can't have an OPS with the
No.
tuition waiver
No.
unless they were EEP or something. I don't know. That's not a waiver.
No, it's not a waiver.
But
Okay, just as a term. So we're talking about that when you're saying with a tuition waiver, you mean they're
Yeah.
they're
So-
by definition a member of GAU graduate assistant.
So what this would mean, practically speaking, the upshot is, like when we talk about the lab in St. Augustine,
Right.
they would only be able to hire TAs. They could not hire research assistants anymore.
Right.
They would no longer be able to hire research assistants. Which,
Okay.
I mean, if that's the position of the union, that's okay.
Yeah.
Our position is not that people are not hired, is that if they're hired, they get the tuition waiver. I don't want that to be.
No, I appreciate, no, it's an important distinction. You're right.
Which we think is,
It's
the
an-
norm is they're hired with the tuition waiver.
Yeah.
I get it.
This is a caveat that we're
Yeah.
trying to limit.
No, that's fine. I appreciate that. It's an important distinction. I don't mean to put words in your mouth.
Okay, so if somebody in English wanted to hire your sociology,
Yeah.
someone in English wants to hire you to teach an English course in the summer.
Mhm.
They need to hire you as a graduate assistant with a
With a
tuition
waiver.
waiver.
Mhm.
Otherwise, and again, just as a practical point, the English chair would need to hire somebody as an adjunct who's not currently a grad assistant.
Not currently a grad assistant.
Okay.
I mean, that, to the best of our knowledge, is how things are going right now, right? Because if you're hired as a GA, you're required to have your tuition paid.
Right,
And
right.
so we're offering a very slim carve out
Got it.
for
No, I
those
think we
very
get it.
small amount of cases.
Okay.
I think we get it. Okay. All right.
If you imagine being hired as a GA for the summer
Right,
and you are not given a tuition waiver, you are still required as a GA by default, right, to be a graduate assistant, you have to take credits. So say I'm teaching summer B, and if someone in English wanted to hire me for summer B but not pay my tuition,
right,
I would only be paid whatever it is, like $4,000 usually,
Right,
because it's a little bit higher than 0.5.
right.
I would be required to pay fees for 3 credit hours and tuition for 3 credit hours.
But if they could hire you as an OPS so that you didn't have to register for classes. I thought that's what one point was
Yeah,
sort
I
of
thought
what we
that's
were
what we were
talking
trying to
about.
do.
Like you could then, if you're a 9-month employee or you wouldn't have to take classes or you're not taking classes anyway, and there's an opportunity to teach. Like, let me put this, so this is a real thing I've had come up before where I've had to make a decision. I'm offering an advertising class. I find out I need somebody to teach it. Yeah, it's like $4,000 or $5,000 as an adjunct. I post that position, a 9-month grad assistant comes in who's not employed, not getting a waiver in the summer. And realizes, in this case, it's an online course and says, ooh, can I apply for that job? And my answer is no, because you would only be able to do it if you're a grad assistant. And I can't afford that. So, and even if I wanted to, what this is saying is I wouldn't even have that option. I'd have to flat out just say no because you're not allowed per contract.
Yeah, because
I
you
mean,
couldn't
yeah.
afford to hire them.
Right, or I could come up with, if I had the money, I see what you're saying, and I'd be like, well, I could hire you, but I'm gonna have to pay you more.
Right.
And that's real. I mean,
Yeah.
obviously, that's
Yeah.
actually what I would probably advocate for, but if the money wasn't there, I would have to say, sorry, I can only afford an adjunct and you don't get to be an adjunct.
Yeah, but that would be the status quo, because if you can't afford
Okay.
to pay them and
Right.
and tuition, that would be what it is currently. So-
Yeah, that is, you're right, it is status quo. I just didn't know if that was part of what we were
Yeah.
gonna change. Okay.
It's also like, not to like use weird words, but like for us, that looks like unit erosion, right? Like,
Yeah.
that's moving someone from a GA to moving them outside of the bargaining unit.
Right.
And it.
I see. Yeah.
In terms.
That makes sense.
I think if you had a guarantee for all of the work, I would agree with you 100%. But I think in this case, because of the cost differential. Because the union's never contested our ability to hire an adjunct to teach a course, especially in a situation where you've got. a
Who
summer
is not a
course.
GA? Absolutely not.
Right, that's what I'm saying.
Yeah,
So it's not, it's not, in the sense that you have a 9-month. If they were doing it during their 9-month term, I would agree, but you're talking about a summer course that's not part of their contract anyway, so it's not really unit erosion in the sense that. They were never gonna get that. That was never work that was promised. to them.
Right.
So. Okay. I think we get it. So I think we're really close on that one. I think what we need to do is we need to go back to the MOU we signed for summer of 24. Because you remember, we did sign this language is different than what we signed in summer, and that was only a 1-year deal. So we just need to make sure that we're gonna have to do some training with our HRLs and our departments. Because this is gonna be different than what we did last summer with the MOU.
Right.
Okay.
And it won't be an MOU, it'll just be.
No, this is gonna be, this is
Right.
a contract, and we're not gonna revisit it for a while, so.
Okay.
All right, that leaves us with 7.
We get that pulled up.
Yeah. I think we're super close on this one too.
Yeah,
What's that? I
I
don't know why, I'm sorry. For whatever reason, the consistency of the ones I did this time is like all over the place.
I can look at the screen.
2, we found it.
Okay. I can look at the screen. I can find.
So
We've got
I
it.
think. The only real changes from what now, granted, I also did some cleanup on this in terms of like colors and crossouts and stuff, so please
Yeah.
go through it all together. But the thing that we really changed is down in 24 through 27. The sentence in general, which what you would suggest is the parties acknowledge that the time spent on assigned tasks is regarded as contract work and is subject to the limit set in 7.1. GAs exceeding so it's a little deceptive because the period after 7.1 is actually the end of that sentence. And then it
Yeah.
starts with an acronym, so it reads a little tough, but that's actually the end of the sentence is at the end of line 25. So new sentence, GAs exceeding contract hours, we changed may to must. Take steps in accordance to resolve being overworked, including but not limited to filing a grievance, and we added in accordance with Article 22. Because we wanted to be clear that it's the same grievance procedure that would otherwise be used, there's not a separate grievance
Right.
procedure. But the reason that must, we went from may to must is because the minute that a GA believes that this contract violation is being violated, we want them to take an action. And if that's filing a grievance, so be it. If it's some other method, so be it, whether it's, if you remember, we kind of went through making A mandatory, and you all were not in favor of that, which is fine, and we're fine, like, okay, if you don't wanna have to do A, that's okay, but you have to do something. And if you wanna file a grievance, then that's okay, file your grievance. If you wanna do A instead, do A instead, but you can't. What we want, it doesn't serve any of us for someone to figure out on the third week of their week into a semester that they feel that this contract is being violated, and then they come to you in week 15 and they're like, hey, starting back in January, my PI was making me work 65 hours a week.
Right, we want to address that as soon as possible.
Exactly.
Yeah,
So I think we have a mutual interest in encouraging our employees to immediately say something.
I think we agree with that, yeah, I think that makes sense.
I have a question.
Yeah, sure.
So if for whatever reason that happens, does this language mean anything to the person grieving, for instance, like, would the grievance procedure go any differently if the person says, I have been, working overtime since week 3, and it is, what do you say, week 15 or
Right.
whatever? Would the grievance go differently?
It's not that the grievance would go differently, but it is an explicit statement that there is a shared responsibility in the sense that the employee should say something if they believe the contract is being violated. They have to take an action. They don't have to file a grievance, but they have to, again, what we said, they must take steps to resolve being overworked, whether that's having a conversation with the grad coordinator, whatever method they think is helpful for them. They shouldn't just not do anything. I mean, anything from, we've talked about all different ranges of things. At one point, we even, if you remember, we actually went down the road of actually talking about forming a hotline or having a committee. I mean, there's all these things that we've talked about with regard to Article 7. So rather than, everyone feels differently, you guys have done a really good job, and I think you've had folks speak on behalf of your union that have said, depending on their situation, there's different levels of comfort in terms of how they would even respond and who they would talk to, and depending on what, some people have a very strong grad coordinator, some people have, quite frankly, have a very weak grad coordinator who may not feel comfortable interacting with the PI. I think you guys have done a good job of showing sort of the range of situations that people work in. And I think what we're willing to say is, look, we're not gonna mandate that you do something informal, but we will make, we do want there to be a statement that you have to do something. You can't just wait. Because as we've said multiple times, when we become aware as administration of people violating the contract, we want to take steps to stop it from happening. And if we don't know, we can't intervene. So,
I think that makes sense, I think we'll have to go back and just double check.
Yeah,
and make sure we agree.
please.
But I think, yeah, we're really close on this, I'd say.
so I do think that, you know, at least I think we brought 5. I mean, I think we're getting really, really close on some of these other ones. We'd love to, whichever ones of these we can get done and knock out, we'd really kind of like to do that.
Yeah, I think, under the table, we have, 10, 16, and it was 25 that you didn't bring today,
20.
one of the 20s. We have 28, 23, and 24, so I think that's 25 on. So that's what we just discussed changing for the, with the.
Oh, well, yeah, because, I'm sorry, let me bring that up. Were you able to have any discussion about, and maybe you didn't, because we didn't give you a formal proposal on it, we just discussed it. Hang on, I can't type my password and talk at the same time. Because it has to be 48 letters long. It's the duration one, I think, Austin.
Yeah, we-
How long- did you guys have any discussion about whether or not you'd be willing to do it 3 years from the time we ratified?
Yeah, I think we talked about it, and I think we're definitely willing to see, whatever you guys bring, and I think
Okay.
we're open to that, I think. There's a couple things we were discussing just to make sure that the process in general is protected, maybe mandating when we would reopen,
Okay.
or start negotiations, so we don't end up where we're a year past contract
Yeah, yeah.
expiration and things like that. But I think we're open to having that conversation to make sure that, it works best for both sides.
Okay.
Yeah.
That's good, because to that point, I mean, I think that based on, I know we've been at this a long time, I would almost, if you're not open to that, I would almost say that the minute we get done, we should probably immediately reopen negotiations, which I almost hate to say that out loud, but I mean, based on how long it's
Based on
taken
the
us.
timeline, yeah, no, we've talked about that,
okay.
yeah. Okay, so that one, and then, 10 and 16.
10 and 16, yeah.
Yeah, and, I mean, I'd be remiss if I didn't talk about those and,
Yeah,
ask for a status
don't-
update on those.
I don't have anything for you on those today. Like I said, we focused on trying to get the ones that were close to try to get them closed out. I don't, in general, I think GAU is aware, some of the language changes that you guys have made, not just the monetary changes, but the language changes regarding restricting our ability to pay wages, insisting that we pay all your fees. I mean, these are things that we've talked about before that are very important to us from a philosophical standpoint. And, while you have made changes to the monetary amount, and I'm not gonna say it wasn't significant from your starting position, because it is, these are not provisions that we're easily gonna agree to remove from the contract. They're just not.
Right, I mean, that's understandable, that's why we come to negotiations, we bring counter proposals.
Yeah.
I mean, can we expect a counter proposal on Article 10 and Article 16?
I think we will be prepared to respond on respond to 10 with some of the language issues for sure. I'll try to focus on bringing that for next time. What about whose side of the table is,
According to our
Is
record keeping,
13, is 13 on your side of the table or is 13 on our side of the table,
according to our record keeping at the end of last session, everything was on your side of the table.
including 13?
Yes,
Okay, so we need 10 and 13 and 16
yes.
and technically 30,
Uh,
not 30, 20,
25,
30's duration.
25. For the duration,
Yeah.
yeah,
25, okay, we will endeavor to have something on all four of those next time.
okay, yeah, I mean, because, I mean, when it comes to 10, I think we made it very clear where we stand, and we made those big movements, and we understand the language for those other things. I mean, that's not something that, it's something that you've stated before, you're not,
Right.
really easily gonna move on, and that's what we say about the minimum stipend each time, and that's
Right.
why we made those big movements, so we could have this discussion and say, let's talk about these things.
Right.
Let's say where we can end up and get this contract done. Because the status quo of not bringing a proposal for 6 months is just not something that we can continue having.
Got it.
You guys have anything else on? 10, No? Okay, I think we're good then.
Thanks a lot.
Thank you.
Debrief.
Debrief, everyone in the chat, just hang out for just a minute with us. We're things set up.
Cassie, you sent me an email. I did not have a chance to read it yet.
It's not that urgent.
Okay.
It's kind of urgent, but like not.
It-
I just wanna.
Do I have until Monday is my question.
100%.
Okay.
Yeah. Are we still recording?
We are.
Okay, cool.